Alrighty, folks, looks like we are live. I'm George, one of the founders of Solo Suit. I have with me John Skiba. Hi, John.
How's it going? It's good to be here again.
Thanks for coming on the show again. Always happy to have you here. Can you go ahead and tell us a little bit about what you do?
Yeah, no, absolutely. Yeah. Like I said, it's good to be here again. My name is John Skiba. I'm an attorney in the state of Arizona, and I primarily represent people. Everybody's dealing with significant debt issues, but I do a lot of consumer bankruptcy, Chapter 7s, Chapter 13s, and then I also do a lot of what I call debt defense. Defending consumers who have been sued by a creditor, who junk debt buyers, those kind of things. We even deal with people who have like old judgments. I can't tell you, it's almost daily I run into people who have these old judgments more than a decade old, weren't even aware that they were there, and then they go to refinance their house or something, and these things appear. So we help consumers who are dealing with serious debt issues like that, wage garnishments. And then kind of how we met, I do a YouTube channel as well where we it's called Consumer Warrior, where we talk about these types of debt issues and try to give some ideas and some resources to people who are dealing with some things that are pretty stressful.
Okay, fantastic. Well, we're going to be talking today about what to do if you've been sued for debt as a consumer and how you can avoid going to court. Folks, if the audio or visual is having any problems, just let us know in the chat and I'll go ahead and get that fixed. Looks like everything's working all right. Hopefully you can hear me and John well. We reserve most of the time for the webinar for any questions that you have, so go ahead and put your questions into the chat. We have lots of people on the webinar tonight, so go ahead and put your questions in there early and we'll try to get to all of them. And if you can give us like a pretty good context, tell us what state you're in, tell us the main terms of the lawsuit. If you're in a lawsuit, just give us a good idea of what's going on. If you can, try to use complete sentences. That's always nice, always a plus. All right, so we're gonna be talking about some of these things. So how to avoid going to court. A quick disclaimer as we get into things, just to deal with some of the regulations in our space. Right, we aren't providing legal advice here. I'm not a lawyer. Solo Suit or Solo is not a lawyer. We're not a law firm. We're engaging with you in an attorney-client privileged relationship here. John is a lawyer. He's only licensed in Arizona, and we aren't providing you legal advice. We're just doing a webinar. All right, so with that, let's go ahead and jump in. John, if I've been sued, can I settle a debt without going to court?
Absolutely. And usually, surprisingly for a lot of people, I often say when you get sued is actually can be a time to actually get the case settled and get it settled pretty quickly. I know a common thing I hear from people is when they're reaching out to the creditor directly or a collection agency. Sometimes you're not sure exactly who's dealing with it. Sometimes it's hard to break through the kind of the customer service levels of all the different credit cards out there. So sometimes, kind of a silver lining of being sued is you actually usually know who to talk to, because the lawyer's contact information is going to be on the complaint and the summons that you received. And that's when you can reach out and try to get something done. In every jurisdiction, you have some time to respond from the time they drop off the lawsuit. That's a good time to reach out and at least see what it is that maybe something can be negotiated. I know here in Arizona where I practice, if I have a client who's like, look, I just want to get this thing settled, they may even have strong defenses, but they understand that it's expensive and it can be a lengthy process to go through the litigation. And they tell me, look, let's just get it settled before we have to go through all that process. It's even possible to often reach out to the attorney and say, look, can we agree on an extension of the to file the answer so that we have some more time to negotiate? And then I always say, don't be afraid of settlement. In almost every jurisdiction, the rules of evidence don't allow the other side to use any attempts of you trying to settle the debt. They can't use that against you in court. So I don't see a real downside to reaching out, trying to get something in place so that you don't actually have to go through the whole process of filing an answer, heading to trial, those kind of things.
Fantastic. Fantastic. Okay, we have lots of questions coming in on the chat here. So you're saying, so in summary, yes, if there's a hearing coming up, settling is definitely an option, and maybe it's even a really great time to settle so that everyone can avoid going to court.
Yeah, settlement's always an option. I always say they want money. If you're offering money, there's got to be some kind of deal that can be reached,
Right,
and
right.
so that's the way to view it.
Yeah, that's great. Sometimes I talk to consumers who are confused about what is the ultimate event in their trial, in their case. So somebody might have like a range of proceedings like on the schedule for their case, right? They might have a pre-trial conference. They might have something called a hearing. They might have a trial. They might have a jury trial. What do all of those terms mean in your experience? And how does somebody know if they show up at court, the judge is going to make an ultimate decision on the case?
Yeah, it's a good question, and it can be confusing to kind of navigate that. And on top of that, each each court, each state is different. Like in Arizona, again, where I practice, there's two different courts. There's courts for anything under 10,000 in our justice court system, and then anything over 10,000 in the superior court system. And they each have different procedures that they follow. But typically, your normal timeline is, you're filing your answer. Some courts will very quickly set a pretrial conference, and usually that's just more of an administrative type of thing where they're going to lay out some deadlines and dates, maybe even give you a trial date, but there's not any final determination that's going to be made. Usually where we see there's some kind of final determination is mediation. Some courts require the parties to go through mediation where they appoint an independent third party to try to negotiate a settlement. That's usually where some kind of decision is going to be made. And then usually it's trials where we see the other one. Very few of these cases make it to a true trial, particularly if you're self-represented. The one thing that the collection attorneys know is that they can usually get a judgment by filing a motion for summary judgment. Summary judgment motion is something where they can enter a final judgment against you. If you receive something like that, you need to take it very seriously, because if you don't respond to it adequately, the court will likely grant it. And they know that for self-represented people, that's probably one of the bigger hurdles to get over, is responding to that motion for summary judgment. So typically a final judgment's not going to be entered unless it's a trial, mediation, or they filed a motion for summary judgment. My one little asterisk to that is like a pretrial conference. In some jurisdictions, if you don't show up or if you're really late to it, the court will enter a default. And so it's important to be on time and participating if you're involved in the process. Otherwise, you run the risk of a default being entered.
Interesting. In your experience, what is the bar for a summary judgment to be achieved? In my mind, like if there's any dispute, if parties say that there's a dispute, then a summary judgment shouldn't be granted. Is that the case in practice? What kind of a bar do judges usually look at?
Yeah, I mean, so with a motion for summary judgment, I mean, the easiest way to describe it is this is the creditor saying, "Hey, judge, we don't need a trial. Just look at all of our evidence and tell us if we win," kind of thing. And usually the standard that the court's supposed to look at it is they're supposed to say, look, if there's any factual disputes between the parties, then summary judgment should be denied. If it's something where the parties all agree on the underlying facts and the judge just needs to apply the law, that's when summary judgment is appropriate. Again, the biggest issue I see is that people just don't respond to it, and then the court takes that as an interpretation that that you're consenting to it almost. So, but if you're responding to summary judgment, it's important to really point out any factual disputes between the parties. If you're getting sued by like a junk debt buyer, like a Midland Funding, Portfolio Recovery, there's usually a dispute between, do they own the debt? How did they come up with the balance that's owed? Did they properly apply all of your payments? Those are the types of things that when I file a response to summary judgment, I really like to point out to the judge to say, look, there are disputes here that are legitimate. And the law typically says in most jurisdictions that the judge is essentially supposed to give you as the defendant the benefit of the doubt at this stage. And so if it could be interpreted two different ways, they're going to say, okay, we're going to err on the side of not granting it. But it's important to point those different disputes out, Otherwise, the court's going to say, look, if you don't respond, or if you just agree to everything, then we'll apply the law, and you're probably going to lose on that.
Yep. Okay, well, we've got lots of questions piling up here in the chat, so let's go ahead and take a look at some of them. We got one from Nicholas. I really made a mistake by procrastinating, dragging my feet, and not responding to being sued for debt in civil court. Feel free, Nicholas. We've all been there to some degree, I think. I am in default. What should I do? Should I contact the lawyer who filed, or should I do something else?
Yes, I would reach out. And depending on how far in default you are, I mean, if the default judgment's already been entered, it's going to be pretty tough to get that unwound. If it's just because there was, you didn't do it, if you procrastinated, it's going to be hard to get that unwound. Again, like I said, you can settle at any stage. You can even settle when there's a judgment is entered. The fact that a judgment is entered means that the judge has said you're liable on it, but it doesn't mean money in their pocket yet. However, the further you let it go along in the process, the less leverage you have to get a better deal as far as settlement goes. Like sometimes I have people come into me in my office and they have a wage garnishment and they say, hey, I want to set up a payment plan. It's way past that. They have a payment plan. It's garnishing your wages every 2 weeks kind of thing. And so the earlier you can get in front of it, the better deal you're going to get, because also they've already taken all the steps. They filed the lawsuit. They have the judgment, and before they get to the garnishment stage, it's a good time to reach out and see if there is some type of middle ground that can be reached. I usually say you should go to them with an offer, though. If you go to a creditor at any stage and say, hey, what will you take? They're going to say, we'll take all of it. You need to go to them with a specific proposal, knowing that they're going to counter you no matter what you offer. But really evaluate your situation, look at your budget, look at your ability either to do a lump sum or a monthly payment plan. What is it that you can realistically do? And I point that out because you don't want to set yourself up to fail on this. You want to do, what's realistic, what can you do, and then go to them and try to get that done. Even at this stage, if a default's been entered, again, they don't have any money yet, and so you're offering something that'll make it a little easier, and you should get a bit of a discount for that. Maybe not a lot, but at least some type of discount.
Okay, great. Taking the next one here, Gabriel. I went through Solo for a response to a summons, and now I have a pretrial scheduled. But I thought a response would avoid going to court. Is that right or wrong to assume?
Filing the answer is just step one. And then that's what, sometimes I think maybe there's some misunderstanding there. Hey, if I file an answer, it doesn't mean it just goes away. It just means that there's a dispute. You look at the way to look at the complaint or the petition is they're saying, hey, here's what we're alleging, the creditor, and then you're filing an answer and saying, well, here's what my response is to that. So basically the court knows, is there a dispute here that we need to resolve? So by filing an answer, that's all you're doing is you're starting this process. It's an important step, and it's a step where even if you're going to settle the case, just by filing that answer, it's going to allow you some time to put together a proposal and get probably a better deal overall. I've seen a lot of people, they'll go ahead and file an answer just because they know it'll extend out some time for, maybe they're putting some money together, maybe they're waiting on a tax refund that they can use to fund a settlement, something like that. It helps you to avoid the default, but it doesn't unfortunately help you avoid the lawsuit in total.
Right. Yeah, Gabriel, we have some language throughout our product and flow that explain that filing an answer is just the first step, usually what we refer to it as. If you have any suggestions on how to make that more clear, happy to hear them. Feel free to email us at support@solicit.com. So filing an answer, avoids a default judgment. That's what it definitely avoids. Filing an answer avoids the default judgment, so you'll get to progress to the next stage. Most of our customers file an answer to use that to then leverage a settlement. So you can go from there. That gives you more time and more of a better position to get a settlement on the case. You can also, you can also file additional documents and continue. Like if you don't have the debt, you can go along that path as well. Question from Will. If you send notice via certified mail that you are represented by a licensed attorney, Must the collector cease direct contact?
Yes. Yeah. Well, once you're represented by an attorney at any stage, they should be contacting the attorney directly. It doesn't even need to be certified mail. And truthfully, in my experience, most collection law firms and debt collectors are pretty vigilant in regards to this. Sometimes almost too vigilant, where it makes it kind of difficult to communicate. But so if you've got someone who's going rogue, um, yeah, I mean that's something definitely to call them out on. And if you have an attorney, have your attorney deal with it. Depending on who the other side is, there may be some fair debt collection practices, this FDCPA law. There might be some violations going on there. And it also might be a sign of you're really dealing with a rogue debt collector who could cause you some other grief as well if they're because that's pretty basic rule under the FDCPA that if they're represented by counsel, you go through the attorney. So I definitely make your attorney aware of that, that kind of communication is still going on. Sometimes it's a kind of an innocent, thing where if you correct them, then it stops, but definitely needs to be addressed.
Yep. Yep, definitely. I'll bring that up with your attorney. Got a question from Armart. With some money saved to negotiate down my debt, what advice can you give as to timing to contact the creditors? So when should I contact the creditors to settle if I have a bunch of money saved up for a down payment or a lump sum?
Immediately. I would reach out sooner than later. Time is generally not your friend unless we're talking statute of limitations type thing. But if this is a debt that's, I think that, I think there are a few pressure points along the way where sometimes you can get better settlements, early on, sometimes right before charge off. I've seen creditors who've offered somewhat better deals, particularly if they sell their debt to junk debt buyers. They might take a somewhat more of a discount early on. But I also wouldn't overthink it too much. I would, if you've got a lump sum, I think that it's worth whoever has the account at this point reaching out. Again, don't offer every penny you have because they'll always counter. But and I always say too, I don't share. I tell clients I wouldn't share financial information right now. I wouldn't share where you work or where you bank or anything like that. But I think it's okay to help them know if you're going through a hardship, if there's been some medical issues, family issues, if you've had job loss, something that really helps, paint a picture of what the whole thing going on here is, you may get a better deal. And if there's extreme hardship, I've seen creditors, I literally had a case 2 weeks ago where we were able to come in and say, look, there's a lot going on here. And they ended up just dropping a lawsuit. So I think that there's never a bad time to reach out. The earlier you do it, generally, the better deal you're going to get. If you let it go too far, you get into litigation. Sometimes there's attorney's fees in that, and then they don't want to sell for a lower amount. So I don't think there's any harm in reaching out and at least proposing something. Just be careful to not. I wouldn't. You're not required to provide all your financial information right now, and I wouldn't, or at the early stages especially.
Nice. Question from Bill. I have an LVNV original credit 1 has a file a motion for me to pay for arbitration. So looks like he's saying, just kind of translating that a little bit, he's saying he has an original debt with credit 1 and LVNV has filed a motion requesting that he pays for arbitration, it sounds like. Is that expected? I guess what should he do next here?
If we're talking about private arbitration, I mean, I don't know if that's clear. If they've like pushed it out of court,
probably private arbitration, I would guess.
Yeah. I always say go back to the terms and conditions of the credit card agreement. I mean, that's what gives the authority for it to be an arbitration in the first place. And it usually will state in there who's going to cover what. So you may want to go back and take a look at that as far as responding to it. I have had a case where I took it through AAA, through the American Arbitration Association, and they prevailed at arbitration. The creditor did, and they tried that. They tried to come in and say, hey, we want the defendant to pay all of our arbitration costs and attorney's fees. And the terms and conditions of that particular credit card agreement didn't allow for it. And AAA even disregarded relevant state law and said that this isn't a state court proceeding. We were going to look to the agreement that brought you here, essentially. So I would go back and look at that really closely. Maybe get an attorney to read over it with you if you have some questions on that. And if they filed a formal motion, you need to respond to it. Again, it always runs into this thing, failing to take action is where a lot of the really bad stuff happens, because failing to respond is often interpreted as consent to the motion that's being filed, and that can cause you some problems. But yeah, I'd revisit that credit card agreement.
Okay. Yeah, and now's probably a good time to settle as well, right? If you owe the debt, you're going to have to continue prosecuting on arbitration. You're going to have to continue going with arbitration. If you filed a motion to compel arbitration, you have to go forward with that. Otherwise, the plaintiff will probably, if they're kind of picking up on this case, they'll probably file for like a reversion on the arbitration if you aren't moving forward with it. And if you get in front of an arbiter, the arbiter is going to behave somewhat like a judge. And if you owe the debt, you're probably going to have to end up paying that debt through the arbitration. But you'll probably end up you could very well likely end up in a better spot if you settle now rather than going down that path.
Yeah, if these are original creditor cases, and by that I always put these into two groups. If you're being sued by a junk debt buyer, again, the portfolio recoveries, the Midland Fundings, the LVMBs of the world, I deal with those a lot differently than I do if Credit One is suing you individually, or Capital One, or Bank of America, American Express. If you take those to trial or to like an arbitration hearing, unless you have like an identity theft defense or like a statute of limitations, you're going to lose. And so settlement early on in those types of cases is really advisable, because they're going to have the documents, the evidence, unless you have one of these kind of real bulletproof defenses, like a statute of limitations, like an identity theft. It's highly advisable, at least in my opinion, to try to get that settled early on.
For sure. Great. Next question from Marvin. I've received a civil lawsuit letter from Midland, but there was no court date for me to appear, and it was dated a month after I received it. What should I do next?
Yeah, I get this question a lot because this is confusing, because you receive the complaint and the summons, and the date is always a lot earlier. Either stamped on there is from when you got it. In most states, the way that it works is they file the complaint and the summons with the court, and then they have the creditor has a certain amount of time to serve you, where they bring it by and drop it off. It could be 90 days, 120 days, whatever it is in your state. That's how much time they have to bring it by. So it's not, that's what you're seeing there. You got it and see that it was filed 60 days ago. It took them some time to get you served. And not, if you look at the summons will usually tell you whether there's an actual court date that's set, or if there's just a specific time period for you to file a written response. Some states require that you actually go to a hearing, and it's set, pretty quickly, 14, 30 days out, something like that. A lot of other states require you just to file a written answer. So read the summons. There's a lot of, usually it's kind of fine print, legalese, but go through there and see exactly what it is they're wanting you to do. If it's just filing a written response, or if you actually need to show up and appear at a hearing.
Okay. Marvin is saying that the answer for the complaint was dated a month after he received it. I'm familiar with the situation where it's dated like a month before they receive it, which I think is certainly something that happens. Have you ever seen it being dated after? So it sounds like he's saying he's served. He might have misspoke, but it sounds like he's saying he was served in like September, but the complaint's dated for October.
I have seen it where, trying to think of what state. It's different from that we deal with here in Arizona. There are some states where they will actually send you the complaint, and then if you don't respond to it, or a settlement's not reached, they'll turn around and actually file it with the court. I have seen that. I don't have a lot of familiarity with it, but I have seen that where there's this process where they don't have to file it first. They can just mail it to the defendant. If the defendant doesn't respond, then they turn around and file the complaint with the court. So it may be something like that.
Yeah, interesting. I think either way, his best move is to file an answer and then try to move forward with the case, right? Probably towards something. Yeah. Cool. We've just got about a minute left here. Let me see if I can wrap up any of these questions pretty quickly. Hannah has been responding to a lot of your questions as well in the chat. She is with Solo, so she's helping us out tonight. Question from FR. I have a debt with Amex. I tried to negotiate the debt directly with the Amex and they offered me 75%. I didn't settle. Lawyer now is getting involved to sue me. I answered the lawsuit with Solo. Okay, that's good. 75% settlement is pretty good. If it's pre-lawsuit, like a good deal is usually going to be more like 45%. 75% is like a good deal if you're self-represented while a lawsuit's happening. Question from Will T. What if I refuse to pay the third party and say I only pay the original creditor? Will, that wouldn't really make sense. It might sound like it makes sense, but it's not a good move. The third party in this situation has bought the debt from the original creditor, so you can't pay the original creditor now. You can only pay the third party. Let's see. Question from Tom. A debt collector got a judgment against me without notifying me. How can I get that judgment dismissed? I have attempted to settle. So you want to file a motion to set aside judgment and say that you were never served properly. And with that, file an answer document and then try to get it settled. Another question from Lee. We sent a phone to Apple, but T-Mobile is on his credit report. Not quite sure what's going on there. If you have T-Mobile on your credit report, you aren't being sued for it, maybe you can send them an FCRA dispute letter to the Bureau to get that removed. You could also probably try contacting T-Mobile. If there's a debt that you need to pay, go ahead and pay that, and then that will be, it's probably the best way to resolve it. It'll show as paid on the credit report. Question from Cardo1. There's a trial set for January. Can I expect to hear from them about discovery, or will they just show up at the trial and win? I did file an answer using Solo. I don't have any money to settle. You'll probably hear about them regarding discovery before the actual trial. And you'll probably want to try to settle before that if you feel like you owe the debt. John, you have anything to weigh in there about discovery? Is discovery always filed before trial? I believe that it is, yeah.
Yeah, I mean, there's usually at least disclosure. Usually there's what's called an initial disclosure statement that's got to be submitted well in advance of trial. And if something is not disclosed to you prior to trial, like if you show up to trial and all of a sudden they pull out, 2-inch thick of, monthly statements that you've never seen before that they haven't disclosed, you can object to those being admitted. I've had that happen numerous times where there's documents that had never been disclosed that show up at trial for the first time. So, you should get some kind of disclosure well in advance of trial. Like in Arizona, it's due 30 days after the answer's filed. So even if that late, if your trial's already scheduled and it's coming up, you may have a defense there to get those thrown out.
Yeah. Okay. Well, that's all we have time for, folks. We're about half past the hour. Thanks so much for everybody showing up. As always, we are here to help you out. We're connecting consumers with collectors, making it easy for all the parties to settle. John, thanks so much for coming on. Where can people find out more about you?
You can look me up on YouTube, Consumer Warrior, or my law firm's website's consumerwarrior.com. Particularly if you're in Arizona, I'm happy to help people out and I can talk to them specifically about their case. If not, over at my Consumer Warrior YouTube channel, we have over 800 videos that talk about this stuff all day long. So nice. Those are good places.
Yep, they're great videos. Check those out. All right, folks, and next week is Christmas. Merry Christmas to everybody. Happy Hanukkah as well, and happy holidays.
Okay.